Florida.
Good morning, Your Honors. Andrew Crawford. I represent the appellant in this case, Deandrick Keon Bacon. I'd respectfully request 5 minutes reserved for rebuttal.
5 minutes? Very good, Mr. Crawford.
Your Honors, this case arises from Manatee County for conviction of multiple drug offenses, specifically sale and possession within 1,000 feet of a school, trafficking in heroin/fentanyl, as well as possession of heroin and fentanyl. These occurred on 2 different dates, on May the 23rd of 2016 and again on June the 3rd of 2016. There is multiple issues cited within the initial brief. I'd specifically like to discuss 2 of those issues with Your Honors this morning. The first one would be the trafficking case. In the brief, we specifically submit to the court that there was insufficient evidence to prove that there was that the defendant in this case, appellant Mr. Bacon, possessed the drugs in question. As the court knows, when he is not in actual possession, he's got to be in constructive possession, which means 2 elements must be proven. One, that he either exercised dominion and control over the drugs, and he had knowledge of their presence. In this specific case, we have a house searched in Manatee County, Florida. It was in the possession of, no one was present at the home. The trafficking amount of drugs were found in a closed cabinet. There was no DNA, there was no fingerprints, there was no any type of forensic evidence forensically linking Mr. Bacon to those drugs. Additionally, when law enforcement conducted a search of the residence, a detailed search of the residence, there was identifications from multiple individuals, 4 other individuals as a matter of fact, including the defendant's girlfriend at the time, who was similarly charged but not with trafficking. She was charged with sale and possession in the same information, which was filed on the amended information, which was filed on November the 16th of 2016.
Let me ask you, Mr. Crawford, because
Certainly.
we get to look at the circumstances of
Correct.
the case, and correct me if I'm wrong, as I understand what happened is that, because that argument was made below,
It was.
and the court basically found that, based on the testimony, that this was not the first time that they've observed your client coming out of his home and then proceeding with making this sale, correct?
That is correct.
And they verified the fact that he owns this home. This is his home. There's no question about that, correct?
Incorrect.
Incorrect.
Incorrect. There is, in the record, I cited specifically in the reply brief, the house was rented to his girlfriend, not rented to him. His name was not on the cable bill, his name was not on the water bill, his name was not on anything associated with the house. And in fact, he moved out of the house days before the search and was actually 10 miles away staying at a motel at the time of the search. So, Judge Kazam, I would respectfully submit that, no, it wasn't his, there was not ownership proven of his house. Conversely, there was more ownership proven of the non-charged co-defendant, his girlfriend, because there was a rental agreement in her name.
Okay, so my question next one, did he reside, I thought there was evidence presented, maybe I indicated ownership. Did he reside in the home?
There was some evidence presented that he had resided in the home previously. For example, law enforcement conducted a search from March of 2016 through May of 2016. And they had seen Mr. Bacon going in and out of the residence. But his girlfriend also resided there. It wasn't like his own house. There was more than one person living at the house, and obviously there was multiple pieces of identifying information connected to other individuals. Furthermore, the location of the drugs was in a closed kitchen cabinet. It was not in plain view, and there was no forensic evidence linking him specifically to those drugs.
Let me ask you a question, because you would agree that a judgment of acquittal cannot be granted, can only be granted when there's no evidence that exists to convict, correct?
No, Judge.
Is that not the standard?
The standard is a de novo standard of review, where the court can look at that. Of course, there's a presumption that you have to resolve all factual disputes in favor of the state.
All inferences are in favor of the state.
Correct.
Now, a reviewing court can consider what may appear to be incriminating statements, correct?
It can.
And can also consider the totality of the circumstances, correct?
When looking at specifically a constructive possession theory, the court looks to whether there's incriminating statements, facts as it relates to the case. I don't think the court is necessarily bound by the based on the de novo standard review, this court is not bound by what the trial court found and can look to
But,
the
I
record.
mean, we can review it just like the trial court did.
Correct.
I know it's de novo,
Yeah.
but my point would be this. On May 23rd, 2016, he was seen leaving the home.
He was.
Sold heroin and fentanyl in capsules, and then he returned to the home. On June 3rd, another sale of the same substance was arranged, and the defendant agreed to it and even told the undercover officer, that he was on his way to the DMV, and your client was arrested at the DMV, and he possessed the same identical type capsules with the same identical substance, correct?
That is correct.
Okay, so minutes before his home is searched, he is arrested and found in possession of the same identical mixture of substances in the same identical capsules that are ultimately found in the home. Is that correct?
I'm not sure on the timing, whether it's minutes apart, Your Honor, but...
Same day?
Same day.
Okay,
There-
same
there-
day.
there is
So you have jail calls
Correct.
where, that stuff, he said something else, but that stuff came together, it came like that, and that's subject to interpretation, mixed fentanyl and heroin, correct?
Correct.
Okay, I did not know that stuff had fentanyl in it, which could be interpreted as an admission to the sale, correct?
It is...
And then I did not add or put anything in it, which means an admission to the possession of this same type of substance. So it seems on each encounter with the defendant, Mr. Bacon, he possessed the same drug mixture in the same capsules that coincidentally, I guess, were found in his home. And then there was a fingerprint on an empty container of capsules, correct?
There was 6 feet away from the closed kitchen cabinet.
So are you arguing that's not enough evidence to go to the jury?
I am,
Based on what? What case?
based on the cases I cited within my
Which is
reply brief.
which is your best case?
Well, there's a number of different cases, Judge. One of the main cases I cite is the Brown case. The Brown case, which came from this court, which was also in Manatee County, was a case where the Bradenton Police Department and the Manatee County Sheriff's Office obtained a warrant to search a residence. Officers had just seen the defendant and a undercover informant, a confidential informant, leave the residence. They made a drug transaction, and then then officers came in, searched the house. They located a number of scales, razor blades, cocaine, heroin that was in plain view in the dining room. They interviewed the defendant, and the defendant specifically said, yeah, you're probably going to find my fingerprints on that. In a jointly occupied...
what?
On the paraphernalia.
Paraphernalia, correct.
Not on the drugs.
Not on the drugs, but on the paraphernalia, which well, the drugs were on the paraphernalia, so obviously that's possession. But he admitted specifically that, and there was also narcotics found in a jointly occupied area, and this court said that that wasn't enough, even though he admitted that the other drugs were his.
But to take to Judge Sleet's point, I think one of the ways that this can be distinguished, bracket aside the jail calls for a moment. All right, cabin that issue, because I think there's some questions about that, about what he's talking about there. Given the unique admixture that's at issue here, it's almost like a unique identifying marker of the drugs themselves, right? I mean, in other words, it's not quite the same as putting his fingerprint on it. But it is, this is not like saying, yeah, he was selling some heroin over here, and we found a bunch of heroin over there, and so we're going to just assume that he constructively possessed the trafficking amount of heroin over there. Instead, what we're saying is, hey, we've got this really unique mixture of heroin and fentanyl that he just happened to be, that he was selling over here. He had just left the house and about to engage in that transaction, and there's the exact same unique admixture of heroin and fentanyl over there.
I understand what Your Honors are saying, but the flaw to that argument is his girlfriend, who lived in the same house, who had more of an ownership interest in that residence, was charged with selling the exact same stuff.
Sure, and that's a great issue to put before the jury when you're raising the defense that, hey, the state did not prove that he was in constructive possession, but for purposes of a JOA,
It is absolutely appropriate to bring that before this court, because one of the issues is who else had possession of, and who else, obviously there's a reasonable hypothesis of innocence, of course, which I mentioned in the brief. But his girlfriend was charged with, you can't say that a individual was charged with selling a unique type of substance, therefore he had possession of control over it and knew about it, when his girlfriend is charged with selling the exact same thing, who had more of an ownership interest in the property.
And how do you respond, Mr. Andrews, to follow that? The same type of mixture, the same type of drug, same type of everything was found in his car as well.
Well, it was also found in her possession as well.
Okay.
And he
Well,
wasn't living there at the same time.
Then why
But we're
can't
not-
they both be in constructive possession of the same thing?
Because it's a jointly occupied
That
residence,
argument kind of
Judge.
defeats yourself. Really? Because it appears to me they're both selling the same unique stuff. They're both in constructive possession of the same unique stuff found in the home that they jointly share.
Well-
Now, if she didn't have any involvement at all, maybe it's different. I don't know. But
Well, Your Honors, there's a number of other cases that I cite specifically in the reply brief, okay, where, they search a jointly occupied residence and the guy says, I think they found it. That wasn't sufficient. Your Honors, in terms of the jail calls, yes, there are some admissions made. Of course, as a defense attorney, I wouldn't like those jail calls to be there, but they are. But when you're looking at the jail calls, what he is talking about, you have to look at them in context. You can't isolate one specific statement. When you're looking at those jail calls, he's talking about the sale of a controlled substance within 1,000 feet of a school. That's what he's talking about. If you keep reading down, that's what he's talking about. He's wondering, how can you charge me with both of those when I only sold one thing, which kind of dovetails in the double jeopardy issue. But, Your Honors, that's what he's talking about. He's not talking about stuff in the house. And specifically when he's talking about the house, he's saying, I don't live there. I don't stay there. There's no bills there. There's no water bills there. There's nothing like that.
he's actually talking about two different things, I think, sir. Because he starts out talking about, because he's perplexed. Matter of fact, he sounds like he's a little angry that his stuff was, as, I can't remember the street parlance anymore, was stepped on or whatever they used to call it.
Cut.
Weakened by something else. He's surprised. So that's a totally different issue than, a couple of statements later, well, how can you charge me with 1,000 feet of a church? See, he's already talked about this mixture, so he's showing knowledge of a unique mixture of a controlled substance. So how can we ignore that as we review the search of the home?
Well, because, Your Honors, in terms of actual and constructive, obviously there's a difference between the two. The home is a jointly occupied home. He's talking about a mixture of drugs, and the drugs he's talking about is for, the sale within 1,000 feet of a church. That's what he's talking about. And when in relation to the home, in terms of incriminating statements in relation to the home, he specifically denies and says, he says, I don't live there, I don't stay there. In fact, the defense attorney below presented independent evidence that he wasn't even at the house at the time. He wasn't living there. He'd been kicked out by his girlfriend, and he was 20-minute drive away, 9.1 miles away, staying in a motel. So the day of the search, and they found nothing in the motel room, by the way.
But Mr. But how do you, and I appreciate all that, but there's also, we have to look at what's in the record.
I understand.
What was presented to the court. Wasn't there also the following presented, where he was seen coming in and out of the home
There was.
to make sales of the same capsule containing the same heroin cut, the same fentanyl, and then that's what, so he has been seen going in and out with that same, to use Judge Lucas, almost like a fingerprint type of drug, which is kind of unique. And the search of the home revealed the same, the package of empty capsule addressed to him, and has a digital scale, it has the whatever grams, and that's in the place. So we can't just look at in isolation saying, oh no, he's denying that he's there, but you have to look at evidence, and then to follow what Judge Sleet said, this is on a judgment of acquittal. You get to see all of that.
Correct.
And how can we discount that information?
Well, I would rely upon the case law that I cited specifically in both briefs. I think that the Brown case is particularly instructive because the facts are much more incriminating there when they watch. Law enforcement actually watches the sale, and the guy has the marked bills on his person when he's arrested, and he admits presence, admits ownership of the paraphernalia on which residue drugs found, stuff in plain view. Furthermore, he was there at the residence. They had watched him leave that day. That is a much more incriminating case than this case.
And Mr. Andrews, you're right about to go into the rebuttal. Would you like to stop right now or keep going?
Well, I need to bring up briefly, I will bring up that the two sales charges,
right,
which occurred on the same day, violate the principles of double jeopardy in both the Florida and the state constitution. It was one sale, it was one sale, one transaction, the same pills. Double jeopardy should preclude Mr. Bacon from being charged with both of those offenses when they took place, same transaction, same location. I'd respectfully ask the court to reverse and remand on both of those issues, and I'll reserve the balance for.
Very good. You have about 4 minutes
Thank you,
in rebuttal. Thank you, sir. Okay. Mr. Shaw?
May it please counsel, may it please the court, Michael Schaub on behalf of the state. As to the first issue, there was competent substantial evidence to prove possession, specifically constructive possession. I believe your honors noted what my argument would be in terms of the constructive possession argument is the fact that you have this investigation and then you have these statements. So the circumstances plus these incriminating statements are independent proof that exhibit that the appellant had ability to have dominion and control and knowledge of these drugs.
Bracket the statements for a second, because you can read those a couple of different ways. But on the notion that this is kind of a unique one-of-a-kind drug, I mean, it's heroin that got cut with fentanyl. There's probably a lot of that around, I got to imagine, right? Is it really that unique? Is it so unique such that we can say that in and of itself is independent proof that he actually was aware of the presence of this heroin cut with fentanyl and that he had dominion and control over it? Because besides that, you really don't have, there's really not a lot in this record other than the capsules, and the most that gets you, though, is constructive possession of drug paraphernalia, because those were empty capsules.
Well, I think it could be inferred. So I think all these factors, you have the capsules, you have the heroin cut with fentanyl, you have the investigation of the different dates of sale. So you have this May 25th sale.
Yeah, okay, I mean, established, he's a co-resident, done. You still got to show that this is, because of where this heroin cut with fentanyl is found, that it's within his constructive possession. What independent proof do you have as to DeAndrick Bacon, that's DeAndrick Bacon's heroin cut with fentanyl?
The fact that he sets up a sale on June 3rd, he's seen going to that
okay,
house
so he's
on June
selling
3rd.
drugs, but I mean, you still got to prove that he had possession of these drugs, that it wasn't somebody else's.
I'd say you can reasonably infer by the fact that on that day he goes to his house and it's heroin cut with it's packaged with.
Listen, if I were writing on a blank slate, I'd say infer all day long, all the way. But the case law says you got to have independent proof, and the case law tells you how you get to independent proof, which doesn't seem to. It seems to contemplate the notion that yes, constructive possession is often going to entail inferences, but because of that, we're going to require something a little more.
Well, I think the independent proof says it can't just be on ownership, right? I think what that Robinson, I believe the case is, says what cites the independent proof. It says it just can't be based on ownership, but you can look at the incriminating statements and the circumstances surrounding to infer knowledge. So you can look at those circumstances to infer knowledge and ability to control. I mean, you can infer that through that. You just can't, the independent proof says you just basically can't, just because he's owning the house, if he's in joint possession, you can't infer through that ownership the possession. But I think in this case, you have the additional circumstances of that investigation, and I think you can't limit out the statements that were made, the incriminating statements about that he has knowledge of there is heroin cut with fentanyl. but he just didn't know it was
So
stepdaughter.
this guy lived with, a dozen drug dealers.
No, he didn't live with
No, I'm saying
okay,
if he lived with a dozen drug dealers and he himself was a drug dealer and the police come and a validly executed search warrant, find an unnamed, unmarked package of drugs that all dozen drug dealers were selling with. We can pin it on this one guy because, well, he was selling drugs.
So you're saying there's a dozen drug dealers in this house?
Yeah.
Police go in on a search warrant, they just find these drugs.
In a out of plain view place, he doesn't cop to being his drugs, nobody cops to it being their drugs, but we can definitely pin it on defendant number 7, who happens to be Deandrick Bacon, let's just say.
Without any of the circumstances in this case?
Add all the circumstances you want from this case. You've got a
Yes,
phone call. You've got a phone call where he's maybe talking about that, but probably isn't. Maybe isn't. I don't know. And
No,
you've
I
got the
think
fact that he was selling drugs, just like the other 11 drug dealers in the hypothetical house I'm giving you.
I think given the circumstances in this case, if you had 11 drug dealers, yeah, you can have the reasonable inference that he's going to that house, that's where his drugs are. He's cutting those drugs, he's packaging the drugs, and he's coming out and he's making the sale on that day.
Okay, so your argument would be it doesn't matter that there's a dozen of them there. All for one for all. We're a happy commune of drug dealers. We're communally owning this, and the state can rest on that, and that's all they got to show. They don't have to show the one person they happen to be charging and trying to convict. They don't have to show it vis-a-vis that defendant. They can just show that, hey, if it's there and all these drug dealers live there, it's got to be all of theirs.
If they can make the reasonable inference for the evidence that the defendant is going to that house, he's cutting up the product, he's putting the product in a packaging that's addressed to him, and he's
You don't have
going
any independent proof that he was doing that. You've got a package of empty capsules with his name on it, and you've got an unnamed stash of heroin with fentanyl. That's what you got. And you got him selling drugs outside the house.
But all reasonable inferences must go to the state, and I think you can infer that. So I think it's reasonable to infer that that's what he's doing based on these previous sales and based on the statements in the jail calls.
Okay.
It's a judgment of acquittal argument. I think these are great arguments for a jury to hear on closing, but it's a judgment of acquittal.
Well, you don't get to
argument.
bring the hypothetical before a jury, but I hear what you're saying.
But it's competent substantial evidence. So I believe the competent substantial evidence would support the construction.
Mr. Schaub, the point that Mr. Crawford made, that based on, there's some testimony that he actually moved out of the place, that he was not living there, he was not residing there at the time. Would that make a difference in the equation?
Given the fact that, that's his hypothesis, I wasn't there at the time, but you have it on June 3rd, you have a cop sitting on that house and seeing his car come up, he go in on June 3rd day when he knows he has to make a sale, then he comes out, minutes later, he's found at the DMV with the drugs in his possession. So, no, I don't believe, given that evidence on the June 3rd, they were sitting on that house. So that rebuts, hey, listen, I wasn't there, I don't know what's going on to that house. Because he's making a sale, he's arranging a sale, and where does he go? He goes directly to that house, because that's the source of where his drugs are.
Okay, so Brown has a little bit of that fact pattern with the CI making the buy at that home and then the defendant ultimately leaving the home and then the search warrant on the same home shortly thereafter. So you've got Mr. Bacon going into the home on June 3rd. He's going to stop at the DMV on his way to the second sale, right?
Yes, sir.
What distinguishes this case from Brown other than the uniqueness of the mixture?
The statements. I think the statements.
Jail calls or?
The jail calls that he makes.
Well, okay, there's been argument that the jail calls may only be related to the sales. If you read the jail calls, are you saying that they're subject to interpretation and it should be a jury decision as to what they're making reference to?
Given the fact, and I keep harping on this, I apologize, but given the fact that you must take all conflicts or disputes and evidence in the light most favorable of the state, yes, I believe that when you see those jail calls and you're making a decision on the judgment of acquittal, you must reasonably infer those jail calls mean that he's talking about all the drugs that he's possessing, including the trafficking amount in his home.
Okay, so if you look at his statement saying, I didn't know that was in it, I didn't know it was mixed, I didn't know it came that way, this defense's argument is the only conclusion you can draw from that statement is it is referring to the sales and not anything in the house. Do you disagree with that?
I disagree with it, given all the circumstances of the case, yes, sir. And the other issue I want to tell you, just the ownership of the house, that Rashonda had more ownership of it. Evidence of Rashonda's license, driver's license, it doesn't even come back to that home. If you look at all the evidence for DeAndre Bacon, you have the registration to that Infiniti that he was seen driving around that day. It ties back to the home. When he checks into the Best Western, he uses that as his address for the Best Western receipt. You have a banking document that ties into that house that's addressed to him, and you have the packaging that's tied to him at that home. And the other thing I wanted to note and just point out in the jail calls, and it was in a reply brief, and I just want to mention it, and I think it's pertinent, is the fact that the defense cites in the reply brief that he says the stuff, use your language, Your Honor, the stuff that they found in the house, they can't charge me with that. And the defense says and argues, listen, it shows past knowledge that, okay, he knows they found something based on, what he's heard. But what's actually said in 852 in the record is the stuff they find in the house, they can't charge me with. So I think the find and that they found are pertinent differences, because the stuff they find in the house they can't charge me with indicates he's expecting them to find that heroin in the house, and it is inferred from knowledge of that. So I just wanted to point that out. And as
Or was a paraphernalia that had his name and address on it.
Again, you can infer that.
Yep.
That's a great argument for closing, but infer a judgment of acquittal, I don't think. You have to have the reasonable inference to the state.
Because what is the legal for, we have a bunch of students here, so we're talking about judgment of acquittal, so what's the legal standard?
The legal standards is that there has to be sufficient evidence, competent substantial evidence establishing all the elements of the crime. And all the reasonable inferences and conflicts must go to the state, and it's a de novo review based on legal sufficiency solely, is the legal standard. As far as the double jeopardy argument, there's two different elements that each sale doesn't require, and that's the element of what he's selling. I cite, they're out of, and I did it in a notice to supplement, they're out of North Carolina and Ohio, these cases. And the one out of North Carolina, basically, person's found with a pill containing ketamine and I believe it's ecstasy. It's a mixture in one of these little capsules. Court says no. Each sale or each possession requires a different element to prove. And I think it would defeat the purpose of 775.021 to say it violates double jeopardy, because it's the intent to convict on each criminal transaction in an episode. So basically you can skirt this by just packaging the drugs together and selling them as one. So that would be my argument for double jeopardy. And based on all these arguments, I'd ask this court to affirm the lower court's ruling. Thank you.
Very good. Thank you, Mr. Shaw. Mr. Crawford, you have 4 minutes, sir,
Yes, Your
for rebuttal.
In respect to the argument that the residence was not in Rashonda Spates, who is the defendant's co-defendant and girlfriend at the time, I direct the court to page 201 of the record. There is a letter from, I believe, the Manatee County Housing Authority, specifically relating to a rent adjustment, where she is the renter of that place. It's on page 201 of the record.
That was admitted into evidence?
Correct, yes,
Yeah.
sir. Okay, that was in evidence, so.
And Mr. Crawford, just to respond back to
Sure.
what Mr. Schaub said in terms of the bank document, in terms of his car license and all of that.
Mhm. Well, at best, it shows at one particular point in time, and I'm not conceding this, he may have been an occupant of the residence. But, inferences, it's not inferences, it's got to be by independent proof that he constructively possessed the narcotics that were found in a jointly occupied residence, which again, he wasn't there at the time. He was at a different location.
But is it true in the evidence, I didn't read it, but that particular part, but that he was observed going to the home and leaving the home before going to DMV?
I don't recall. That is not my recollection of what the record shows. My recollection was there was a phone call arranged, and then he was at the DMV. I don't specifically recall whether or not Mr. Bacon, went into the home on that particular day, retrieved the narcotics, and then went to the DMV.
Would that make a difference?
I think that would be important, of course. But still, there's got to be independent proof that he, again, possessed it. I mean, there's no fingerprints, there's no DNA. This court had a very similar finding in the Santiago case, which I cite. there are drugs found in a lockbox right on top of the defendant's identification. And this court said, hey, that's not sufficient for constructive possession. I mean, we clearly don't have that here. Also, in the DeJesus case from the 4th DCA that I cite, this guy's charged with burglary and grand theft. The loot from the burglary is found in a Sports Authority bag with his fingerprints on it, on the bag itself. But the 4th District Court of Appeals said, hey, that's not sufficient, even though he's got the proceeds of the robbery with his fingerprints on the Sports Authority bag. So in response to Judge Lucas's argument, there was some mention of this during the sentencing. The court specifically declined to consider it, but fentanyl is a common cut with heroin because it kind of does the same thing. There's a big issue about that in Manatee County especially. But to say that it's a unique fingerprint type of drug, it's not. I mean, they're both they're both Schedule I substances, and they're frequently found together. And in terms of the constructive possession, whether or not he sold something...
Was that in evidence?
What's that?
Did a police officer, was he either directed or crossed to testify to the fact it's very common?
In the
or
sentencing...
not?
In the sentencing...
No, not sentencing. I'm talking
during
about
the trial.
in front
No,
of the
sir.
judge and
No,
the
sir.
judge assessing an argument for JOA.
No, sir, it was not.
Okay, so then the judge could then consider that it might be unique unless there was testimony to the,
There was
contrary to testimony.
There was testimony to the contrary during the sentencing, I believe, Judge, by Detective Petta, who was the case agent.
Okay, thank you.
Now, in terms of during actual trial, no, but that was actually not one of the judge's factual findings that he made, to my recollection, during the denial of the judgment of acquittal. Again, during the de novo standard of review, the court can look at various things, but when you look at past cases addressing constructive possession of a jointly occupied residence in the kitchen cabinet, where you have multiple other individuals' identification, you have no forensic evidence linking him to the crime, whether DNA or fingerprints, and you have someone else who has a stronger possessory interest in the property. He was charged with selling the identical type of substances. The case law sides with Mr. Bacon in this case. The Santiago case, the DeJesus case, I respectfully ask the court to reverse and remand for discharge or a new trial based on the other issues found within the brief.
Very good. Thank you, Mr.
Thank you, Your Honor.
Crawford. And thank you, Mr. Shaw. Very interesting case and well argued on both sides. Thank you both. Okay. Let me have counsel approach. Thank you, gentlemen.